Harder. We'll call the meeting to order. If I could have members' attention. Pursuant to Standing Order 108-2, we'll continue the study of Canada Revenue Agency's efforts to combat tax avoidance and evasions. And for the first hour, we'll be dealing with Canada Revenue Agency, the Commissioner, Andrew Trush. Have I got that right? Close. Commissioner, you'd appoint Pierre-Luc?
Point of order, Mr. Speaker. Just to clarify, we left at the end of the last meeting. We left a motion on the table, and I would like to dispose of it right now. I don't have any change to do to it, so I would like to ask the consent of the committee to do it right now. I think it will be fast.
It was our intent as a committee to try and actually find 30 minutes at the end of the meeting to deal with committee business, but it's your right to put the motion on the floor if you want. Now you're asking if there's consent to put it on the floor at this time. Do we have consent to deal with it now? Everybody in agreement with now?
I think we should respect our witnesses' time, and I think there'll be ample time afterwards to debate the motion, because the debate might go longer. And
I'm not hearing consent, so we'll deal with it it will be the first item we deal with in the last 30 minutes. Okay, Mr. Commissioner, the floor is yours. I would say, Mr. Commissioner, to start on the KPMG Isle of Man CRA issue. I've been a member for a long time, quite a long time, and I've got as many calls on this issue as I have on any other, because I think Canadians are quite frustrated that they believe, whether it's right or wrong, that they believe that there is unfairness in terms of how people who can afford accountants and the wealthy are treated under our tax system versus those that are doing it on their own and have to deal with CRA on an individual basis. So I just say up front, from an MP's perspective, and I think most are getting the same kinds of calls I am, this is an extremely serious issue from, if I could put it this way, an ordinary Canadian's perspective. So the floor is yours, and I just state that so that you know that this isn't an issue that we as committee members are taking lightly. The floor is yours.
Je vous remercie, Monsieur le Président. Thank you, Mr. Chair. I should indicate I'm happy to stay for the duration of the meeting. And can I say at the outset that on behalf of all CRA employees, all our prayers and thoughts are with the people of in Fort McMurray and the first responders there. With me today are Mr. Ted Gallivan, the Assistant Commissioner of the International Large Business and Investigations Branch, Ms. Stephanie Henderson, the Manager of our Offshore Compliance Division, Ms. Lynn Lovett, the Assistant Deputy Minister of the Department of Justice, Tax Law Service Portfolio, and Ms. Diane Lorenzato, Assistant Commissioner of the Human Resources Branch. Canada's tax system features a level of voluntary compliance. It's among the highest in the world, but offshore tax evasion, aggressive tax planning remain a challenge requiring both concerted action here at home as well as global strategies. Increase in international trade and globalized investment flows have resulted in complex multinational corporate structures, use of offshore jurisdictions of concern, and profit-shifting schemes that challenge all tax administrations. CRA is responding through a 4-point action plan to effectively target this globalized tax environment and related non-compliance. Our plan includes, first, better access to information; second, a more focused organization targeting offshore non-compliance; third, increased resources to deepen our capacity; and fourth, more effective international collaboration.
About two-thirds of the $11 billion that the CRA assesses through audits, over $7 billion, involves our international and large business programs and aggressive tax planning, including high net worth individuals and multinationals.
Non-compliance by those using offshore schemes has never been better. In large measure, this is because we've significantly improved our information tools. Since January 1st, 2015, financial institutions are required to report international electronic fund transfers of $10,000 or more. This information is invaluable in helping the agency target jurisdictions and financial institutions of concern. Second, the process for using unnamed persons requirement, which enables the CRA to pursue information through the courts on taxpayers using offshore jurisdictions, has been streamlined to give us authority to obtain information from third parties such as banks. Yesterday, we applied for authorization to issue an unnamed persons requirement to the Royal Bank of Canada for information about RBC clients linked to the Panamanian law firm Mossack Fonseca, the subject of the Panama Papers. RBC has informed CRA they will not oppose the court application. With court approval, the CRA will receive this information expeditiously. Third, the Foreign Income Verification Statement, this is Form T1135, was significantly strengthened in 2013 to establish more detailed and rigorous reporting requirements for Canadian taxpayers holding foreign property and assets. The volume of these reports has subsequently increased by 50% as a result of our measures to strengthen our scrutiny of offshore activities. And fourth, we're undertaking a comprehensive study of tax gap measurement over the next year, determine how this could be applied to Canada in estimating tax gap. A better understanding in this regard may help us target our compliance activities more effectively. And finally, Canada is very active in sharing information with our international treaty partners. We have one of the world's most extensive treaty networks, 92 tax treaties, 22 tax information exchange agreements in place. These measures also help us identify and pursue non-compliance as never before. Avec son plan d'action, l'Agence publique.
Through our action plan, we have better focused the CRA to target offshore non-compliance. In 2013, we created several specialized teams across Canada and launched a dedicated offshore compliance division.
2015, we reviewed nearly 13,000 international large business files, reviewed nearly 10,000 aggressive tax planning files, fielded almost 2,000 calls to the Offshore Tax Informant Program, where we identified 110 cases for active review. In the last 3 years, we also reorganized our Criminal Investigations Division to focus on the more severe cases of tax evasion and those who promote schemes which enable them. These measures are paying dividends. As a result of these measures, $1.57 billion in additional revenues has been assessed. That's 3 times the initial estimate. In April of this year, we created a new agency branch headed by Mr. Gallivan to focus exclusively on international tax, aggressive tax planning, large business, criminal investigations and strategies to combat offshore tax avoidance. Our organizational changes are supported by a third element of the plan, increased resources. Today, we have more than 6,400 auditors. That's a 20% increase from 2006 at a time of ongoing fiscal restraint. Budget 2016 includes an unprecedented $444 million investment in measures that will increase the CRA's capacity to combat offshore tax avoidance and evasion. This includes a special program to pursue those who create and promote tax schemes for the wealthy. We anticipate this to result in a 12-fold increase in the number of tax schemes examined by the CRA. Comme le ministre Leboutillier l'a récemment announcé.
As Minister Leboutillier recently announced, the agency will also use the funds to hire more auditors and specialists, increasing the number of examinations focused on high-risk taxpayers from 600 to 3,000 per year. And we'll bring in 100 additional auditors to audit high-risk multinational corporations. As a result, the federal government anticipates that its investment in the CRA will generate an additional $2.6 billion in revenues over 5 years.
Must be complemented by collaboration with our international partners. The fourth element of the plan, Canada plays a central role in international fora to address non-compliance, such as the OECD and the Forum on Tax Administration. We recently ratified a multilateral convention on mutual administrative assistance in tax matters, which further expands our international information sharing network. Through our partnerships in the OECD, we are active in several global initiatives. The OECD's Base Erosion and Profit Shifting, or BEPS, project, which aims to address international tax planning strategies used by multinational enterprises to inappropriately minimize their tax. Country-by-country reporting for multinational corporations and implementation of a common reporting standard in 2018. Canada participates in the Joint International Tax Shelter Information and Collaboration, or JITSIC, network, working with G8 and G20 on measures to tackle tax avoidance and aggressive tax planning. We recently participated in a JITSIC meeting in Paris to coordinate next steps related to the Panama Papers. Based on our own source of information, we've initiated 40 audits related to Mossack Fonseca prior to the Panama Papers release. Through more recent efforts, the CRA now has tens of thousands of records from multiple sources. The agency will use this and any other data collected from various sources to ensure that all Canadian taxpayers identified from the Panama Papers are pursued. The Auditor General concluded in 2013 that CRA had done a good job of following up on information received about offshore accounts in the Liechtenstein case, and it improved its process for identifying taxpayers with unreported income.
In 2014, the Auditor General also found that the CRA had the tools to detect, correct, and to deter the use of aggressive tax plans. Since then, our toolbox has expanded considerably.
46 countries at a meeting of the Forum of Tax Administrators in Beijing, China, where we'll further strengthen international efforts. We are making progress, but work remains to be done as we continue to refine and build upon our tools and the most recent investments. It's worth noting that the agency's record has been reviewed twice in recent years, and on both cases, good. In concluding, I think we've provided the committee information very relevant to your study and your opening remarks, Mr. Chair. The summary findings of a recently completed independent review into CRA's management of the KPMG file. The agency undertook this review to ensure that due diligence was followed in our approach to this case. The CRA is in a difficult position of being unable to fully discuss details of the KPMG file due to ongoing litigation and our confidentiality provisions. Having said that, the review conducted by Ms. Kim Brooks, former Dean of the Schulich School of Law, Dalhousie University, confirms that the CRA acted appropriately in its management of the KPMG file. I conclude now, and we welcome your views on questions, myself and my colleagues, on how we can make better progress in identifying, addressing, and deterring offshore noncompliance. Thank you.
Thank you very much, Mr. Troish. And I take it that rather than splitting into 2-hour sessions, we're going to go an hour and a half with the commissioners agreed to stay, so we'll try and get everyone on. Starting then with, and thank you very much, Commissioner, and thank you for the review as well done by Ms. Brooks. Starting then with the government side, Mr. Ouellette, you have 7 minutes.
Thank you very much, Mr. Troche, for coming here, and also for the other officials. It's very much appreciated. I was just wondering concerning the agreement between KPMG and the CRA. I was wondering if there were any internal complaints or concerns by members of the CRA concerning this deal.
Thank you for the question. I'm just looking here at the findings of Ms. Brooks, and I think she actually spoke on this point. She says, the review found that each of the audit files appeared to have been carefully completed by diligent staff. The practices used in pursuing the KPMG case were compliant with established CRA policies and procedures. Now, to your point, sir, while senior management was appropriately consulted and briefed, decisions were made by the CRA team with carriage of the file with due consultation with the Department of Justice. While vigorous discussion about approaches to a file would not necessarily be problematic, there was no evidence of disagreement within the agency on actions taken.
So how do you come about then making a decision whether to pursue with legal proceedings or to negotiate a settlement?
I won't speak about any particular case, but in generality, all tax administrations in their compliance work, litigate, and litigation can end in court. Litigation can end in a settlement. In our case, the numbers, broadly speaking, about 5,000 cases. Over 2,200 would go to a court. About 3,000 would end in some settlement. The determination in each case is built upon the hundreds of hours of our audit team, the specialists who review the facts particular to each and every case, aided by the Department of Justice, who provide legal advice in what is in the best interest of the Crown and in what is the appropriate treatment under the law.
But would financial consideration also enter into that calculation? The amount of man or woman hours involved in calculating out an agreement?
It is a part of the calculation, but the first is what is the appropriate treatment under the law, and what is in the public interest, what is in the interest of the crowd. So it's not a simple calculus. If you go to court, obviously you have an extended process, you have additional legal costs, and I want to underscore this, you have an uncertain outcome. We cannot assume in going to court the Crown will win. And what is of significance is a loss before the court and a judgment which may set back the Crown's ability to pursue these schemes. So all those things are balanced, the facts of each case, as well as the legal risks, the legal analysis.
If you go to court and the Crown loses the case, who's now responsible for the legal fees of the client or the?
Mr. Gallivan?
That would depend on the case, but absolutely some taxpayers do seek costs, and in cases where the CRA refused a reasonable settlement, costs will be awarded to the taxpayer. In other words, the government would have to pay the taxpayer's legal costs. That does happen.
How much more time do I have? Great. So and then there's another thing that's going around in the media. People are concerned about perhaps the ethics of the CRA. I guess people don't like the tax man or tax woman. But there's been some issues, for instance, surrounding the whole idea of cocktails and parties with accountants. And I even have Mr. Gallivan on I believe on record. I have a quote here. We're trying to have a culture in the CRA where executives are trying to be responsive to the citizens that we serve, which includes large accounting firms, and I don't think it's a problem. Now, is this an accurate description of the CR's mandates and culture to serve accounting firms which are engaged in tax avoidance on a large scale?
I'm very pleased to be able to hopefully provide some illumination on the record here. I've spoken to 3 previous CRA commissioners, and as far back as I can tell, the Canada Revenue Agency works with tax intermediaries. Over 70% of the interactions between Canadians, whether individuals or businesses, large or small, there is a tax intermediary between. So it's pretty important that we work with bodies like the Canadian Tax Foundation, which is a body of the Institute of Chartered Accountants and the Canadian Bar Association. It has accountants, academics, and tax professionals, 10,000 members. The Chartered Professional Accountants, which is Canada's national accounting professional body, which certifies accountants, including CRA employees who are chartered accountants.
But for instance, if someone under the CRA was under investigation for some wrongdoings or under suspicion, they could essentially curtail the investigation by resigning from the CRA and then going to work for another accounting firm. Is that correct?
No, that is not correct. If we have someone under internal investigation, and we do it, and we find a criminal offense, we will suspend the employee or we will terminate the employee. And sadly, I have been called upon to do that during my tenure. If it's a criminal matter, we will refer it to the RCMP, and the RCMP will prosecute. On terms of post-employment, I believe the Canada Revenue Agency has the strongest, most rigorous, most effective post-employment directives and policies. I'm quite happy to benchmark myself against other government departments. I'm happy to benchmark us against other tax administrations around the world. We're quite happy to table here in the committee our integrity framework, our directive on conflict of interest, post-employment, gifts and hospitality. And what I would particularly draw the committee's attention to is the letter which Deanne can take the committee through on the obligations that we put our employees in post-employment, including a one-year prohibition.
1 year prohibition, wow. Mr. Chair, I have some other questions. Are we able to give those questions and then
I think you're out of time. Just to clarify on that in layman terms, Commissioner, you're saying that when an employee leaves the CRA, they cannot go to a firm or another business that is in a similar line of work, if I could put it simply, for a year?
I'll ask Jan Lorenzato to explain the provisions.
So the one-year provision applies to all employees at CRA, the 40,000 employees. The 1 year is really based on the activity that the employee was doing prior to leaving. So an employee cannot accept a position with a firm that they were actually dealing with 12 months prior to leaving the agency. They cannot be appointed to a board of director if they were dealing with that company 12 months prior. They cannot represent that company if they were dealing with that company 12 months prior. So we always have to look at what was the position occupying that the employee occupied during the 12 months prior to leaving, what files did they interact on, which will dictate if they will be allowed to take further employment. That limitation is for 12 months. Now, there's permanent limitation for our CRA employee. They fall under the income tax, it's section 241, that prevents all CRA employees from sharing and divulging information pertaining to a taxpayer or any files that they've dealt with during their career. These are criminal offense and they can be put forward for legal proceeding. They can end up with a fine or imprisonment.
Thank you, Ms. Lorenzato. Mr. Coleman, 7 minutes.
Thank you, Chair. From the outset today, the Chair represented that this is a major issue for us. Now, it is, I don't want to diminish this issue, the KPMG news reports. It's mainly being carried by the media. It's mainly being carried, we heard from the KPMG representative earlier this week, which I'll refer to, but I just want to set the context of my remarks, if I might. There are Canadians who are extremely concerned about this issue. There's no question about that. But I can count on one hand, actually, 2 inquiries that have been made to my office about this issue. So it's perhaps not as broad an issue at my constituency level, and I'm just speaking for myself here before I begin my remarks. So I just want to say that and set the record straight for myself on that particular front. Now, just some of the background we've received. Canadians in general are tax compliant. They file their taxes, they pay their taxes. Something in the neighborhood of 95% of Canadians do that correctly. Is that right?
I believe it's over 92%, but yes, we have one of the highest voluntary compliance rates in the world. It's an important observation you make, sir, and it's one of the most important measures of a tax system which is accepted by Canadians as fair and just.
How frequent are amnesty agreements made within the CRA? Like, how are they one-offs, or is there quite a few of them?
You'll recall, sir, I spoke about the instances where we have about 5,000 litigation cases, and that we have settlements in 3,000 of those cases, and 2,200 go to courts. May I say, for the record, we do not characterize the KPMG file as an amnesty. This is a term that has been applied by a media. It is not one that we accept. this matter remains before the court. We are determined to continue to get all of the participants in this scheme, and we want our day in court. Our work is not done. The minister announced as well our additional work on the Isle of Man. This scheme is in Isle of Man. We are now underway with what I would describe as a blitz on Isle of Man accounts up to 800. I will ask Mr. Gallivan to speak in general about the terms of settlements and why amnesty is an inappropriate description.
Could I move on? I've only got a limited time. I appreciate what you're saying. I believe that the explanation, if you choose to give it at a later question point where it fits in, please do so. Without this agreement with KPMG, the negotiation, or whatever it turns out to be, because my experience, having been in business for myself and been audited over several different points in time, that if there are inconsistencies in how we've filed our taxes and such, typically the CRA people are very reasonable with us. We're very reasonable with us in terms of correcting those situations and moving on in a negotiated way. And I would characterize actually my experience that way with CRA. But without this agreement with KPMG clients, do you think the CRA would have been able to recover these taxes owed by these individuals?
That's a very interesting question. I think have asked myself whether, going back in time, if we had all of the tools available to us today, the information sources, we may well have been more successful, but that's probably a question I should invite Mr. Gallivan to address.
I think I can't comment on a specific taxpayer file. So I can speak, though, in general terms about the agreement that's posted to the CBC website and how the CRA generally reaches those kinds of agreed-to settlements. In such cases, payment within 60 days is a clause to such agreements, guaranteeing that the agency would be paid. I would also say and point out that that agreement on the CC website talks about 15 years. In other words, going back 15 years. So, sir, back to your earlier remarks regarding the CRA, in a traditional compliance review, we look at one tax year. Let's fix the mistake and let's move forward back to the voluntary compliance. In our audit program, we do 120,000 audits. We usually look at 1 to 4 tax years. Let's clean it up. And like the statute of limitations, we have a statute barred. We can only go back so far. In the case of aggressive tax planning, the people who engage in tax shelters and those kinds of moves, we actually have the right to go back 6 years. And so we go back 6 full tax years and charge compound interest. A careful reading of the document posted to the website of CBC that I can't confirm is an actual offer of agreement would indicate that we went back 15 tax years. That would be consistent with the CRA's approach to offshore tax evasion, the most serious kind of non-compliance that we detect. So we vary our approach based on the seriousness.
Thank you. Does that, kind of in general terms, does that mean that Canadians can expect this practice to continue as the policy of the CRA to be in the situation where you would bring forth these types of negotiated settlements?
Well, I would say again, I would like to, without taking the committee's precious time, refer to the entirety of my remarks at the outset. We have sources of information we've never had before. Perhaps the most critical being any international electronic fund transfer of $10,000 report is now known to us. This new tool just came to us January of 2015.
Yes.
That's what enables us to tackle the Isle of Man.
Okay. Can I interrupt you, sir?
Yes.
Because I know my time is running thin. Could I have one last
practically
comment?
one quick
One quick question. So, in essence, what you're saying is, over the last 5 years, the new tools that are available to CRA are working very effectively. Is that correct?
Well, some of these tools, they don't go back 5 years. Some of them go back 3 years. Some of them go back 1 year. And most importantly, now we actually have the financial resources to put the effort into it.
Thank you.
Thank you very much. Pierre-Luc Dussault. Mr. Dussault, go ahead.
Thank you, Mr. Chair, and thank you for being here. First, I would like to ask if you can provide the committee, the letter that is on the CBC website, so it can be official in its, it can be provided to each committee member.
I am prevented by law from doing so, sir.
Okay, and thank you. But to follow, I would like to know if you think the tax scheme by KPMG, do you think, in your opinion, is legal?
Canada Revenue Agency uncovered this scheme through our actions. There are on the public record our characterization of the scheme. That's in the public record, and that again could easily be forwarded to the committee.
But do you think the scheme was legal when it was implemented by KPMG?
We would not have gone into litigation if we didn't have concerns about this scheme, and it's why we continue to pursue each and every participant in the scheme.
So, the scheme wasn't legal if you want to pursue a court case?
We are in court to obtain information on every participant in it. We are in court to ensure that the tax assessed are paid in full, and that Canada's tax laws are upheld.
So if you think that scheme is not legal, why would you send a letter to KPMG to transfer it to their clients to have an amnesty? And I call it amnesty because in the dictionary it says, je l'ai en français, c'est un acte.
We'll read in French. It's a legislative act that retroactively eradicates the punishable character of an act.
In the presence of an amnesty. So why, if you think the scheme is not legal, why would you send an amnesty letter to taxpayers instead of pursuing this in court?
We are pursuing it in court. I respectfully disagree with the characterization of amnesty. I think a common sense test, if I may leave the committee, that if any of your taxpayers come to you and they've been approached by the Canada Revenue Agency and asked for an assessment of taxes owing and interest over 15 years and paid within 60 days, I don't think your constituent would characterize that as an amnesty. Mr. Gallivan.
But no, sorry, if you think it's an illegal scheme and the taxpayer signed that offer, if the taxpayer received your letter by KPMG, signed that letter, you still have the power to pursue them in court and take all the money and the penalties and the interest if they have signed it.
Mr. Gallivan.
Again, we can't confirm that actual agreement posted to the website is an actual agreement. However, we would enter into that kind of agreement because in the agency's judgment, in consultation with Department of Justice, after hundreds of hours, we believe there is some legal risk. First, that we would not obtain the identity of the participants. Secondly, that our tax assessment could be challenged and may not stand up in court. We would look at the facts and evidence we have. We would look at the facts and evidence that the taxpayer has. We would look at legal precedents, and then we'd make a judgment. I'd like to correct two other things. First of all, the interest in this case, if one did a hypothetical calculation, the interest would represent a 25% surcharge. A second element, a careful reading of the document on the CBC website indicates there is no immunity from criminal prosecution. The third point is going back 15 years effectively doubles the bill for a taxpayer versus our traditional 6-year aggressive tax planning audit.
Thank you. I would like to ask a question to Madame Anderson. If Mr. Gallivan, you say you don't think this letter is real. Madame Anderson, can you confirm that you signed that letter that is posted on the CBC website?
Although the signature appears to be my signature, I can't confirm the source of the information on the website, so therefore I cannot confirm the origin of the document and whether it would be mine or not.
But can you confirm that you signed that letter?
No, I cannot, because I do not know the source of the document.
But why would your signature would be on that letter if you didn't sign it?
Mr. Chair.
Sorry.
Go ahead. I think it would be important to hear from legal counsel. We wish to be as forthcoming as we can be. but I do want members of Parliament to understand the legal constraints. We are bound by the law as approved by Parliament, and I'll ask legal counsel to explain, if I may.
So,
Go ahead, Ms. Levette, and we'll not take away from your time.
Okay, thank you.
So go ahead, Mr. Levette, Madam Levette.
I'll be short. Section 241 of the Income Tax Act prohibits officials from disclosing information that is taxpayer information. And as such, Ms. Henderson isn't in a position to talk about any of the details of the particular letter to which you refer.
So, thank you, Mr. Chair. So there's a letter that is signed, but you cannot confirm that it was signed. So I understand it correctly. It's a bit surprising. Who signed off on that offer? Because I think, Madam Anderson, maybe you were not alone writing that letter. Someone wrote it at some point. So who wrote that letter, and who was superior to you, who signed off on that action?
I can't speak to the specifics of the case in question or to the letter that you're referring to. Settlement privilege would preclude me from discussing that matter. But if you would let me speak generally to the matter, in any case, I review the facts of the case. I consult with our Justice Council. They provide me with legal advice as to what the risks are and what issues that we may concern with regard to legal precedent. Together we would come up with a draft position. I would then approach my director and in turn my assistant commissioner, who would then, I would present it to them, and then we would move forward.
So that's how it happens. You did all that process to, at the end, came with that letter that is on the CBC website. That's the process you used.
That would be the general process that I would use with any agreement that we may consider in regard to taxpayer agreements. I just point out in the Auditor General report, they did an extensive review in 2013 of offshore agreements and concluded that they were effective and efficient, and that we were using them appropriately and ensuring national consistency.
Direct answer that is available from Ms. Brooks' summary findings. I quote, "While senior management was appropriately consulted and briefed, decisions were made by the CRA team assigned with carriage of the file with due consultation within the Department of Justice."
Thank you. I would like now to turn on the voluntary disclosure program, because it appears on the letter that is on the CBC website. It's you ask the taxpayer to use the voluntary disclosure program. So in the circulaire d'information, du programme de divulgation volontaire,
in the news bulletin for the voluntary disclosure program, it says that it has to be voluntary. It will not be considered as a valid disclosure if the CRA determines the following: that the taxpayer is aware of an audit, an inquiry, or other measures taken by the CRA with respect to the information that has been disclosed to the CRA. So how can you accept a voluntary disclosure when it is counter to the rules? The taxpayer received the letter through KPMG, knew that the CRA had suspicions about the involvement. So how can that person participate under the voluntary disclosure program, given the rules?
On n'est pas dans la possibilité de confirmer que le document.
We cannot confirm that the document on the website is is the CRA's. But I can say, generally speaking, that when there is a legal settlement, it is quite different from the voluntary disclosure program. They are two different programs. And what we look at the facts, we look at the jurisdictions, we look at the national tax well-being, and we make a choice. I can also say this: when it's a matter of principle, there is no legal arrangement. If a legal precedent has been established, there is no arrangement with the agency. When we are 100% guaranteed about the facts, there is no arrangement. It is a legal precedent.
to Mr. Dussault. He was at a time. You finished
Sorry,
your
Mr.
answer,
Chair, I
Mr.
thought that was a signal to hurry up, which I was endeavoring to do.
Okay. Thank you both. And I believe, Mr. Trosh, you indicated that you could provide a paper that was your view of the scheme. Was that what you said earlier in a question?
I think I was citing the summary findings of the independent review of the KPMG thing.
Okay.
Which has been furnished to the committee.
Which we already have, and you already quoted from. Okay, just so we're clear on that. Ms. O'Connell, thank you.
Thank you, Mr. Chair. Thank you for your appearance here today. I'm going to focus my questions based on the summary findings, item 2, in regards to the finding that the deal with KPMG was not inappropriate because it's consistent treatment of taxpayers in similar situations. I really want to focus on this because I have, like the chair has stated or at the onset, I have very serious concerns with how taxpayers working with CRA tend to be treated, the average taxpayer I'm talking about. So what are the criteria to enter into a settlement versus litigation or going to collection services?
Thanks for the question. So I want to be very careful with Ms. Brooks' summary. I will cite from it, but these conclusions are her own, and it's not for me to read into her findings. She obviously is looking at tax law, in which she is an expert, if you look at her here, and she's looking at jurisprudence. She's looking at decisions of the court and how they bear upon her review of it. But this is her opinion. I'm citing it, etc. Back to the remarks I've made earlier, each and every case has its own determinative facts. And that is why auditors spend hundreds of hours in assembling the facts on each and every case to find the right treatment for that case. And it's why they work with Justice. Justice understands not only the law, but they're active in understanding the jurisprudence and the decisions and how that the risk or the benefits of going to court. And they have to make that decision on each and every case. And that is why you have Ms. Henderson here, her team. You would have had a team of a few people that would have worked on this file for many months. And increasingly, they would have been working, seeking legal advice to make the appropriate determination, as we would with any taxpayer.
Thank you, Mr. Chair. I just want to, without offense, I will say that it's hard to hear that you refer to this document to the credibility of the actions, but then when I'm questioning specifically a statement that this is how taxpayers are treated, let's be very careful here, because if a determination of treatment is about hours and legal success, could you not argue that someone who has paid KPMG $100,000, who can afford lawyers, versus the average Canadian, like someone in my riding, who might owe CRA $1,200, and they have their Trillium and HST garnished, single mothers? How do you think that if the determination is based on hours in court or accountant fees, how would the average Canadian who can't afford a $100,000 fee to KPMG, how is that a fair treatment across the board for all taxpayers? And with your earlier statement, if Madame Henderson is someone that has worked on this file for several months, in my constituency, it takes 9 to 12 months just to receive a response on an appeal. 9 to 12 months to get a response. And we can only communicate with CRA via fax. So may I have your phone numbers or email addresses so that my constituents can start negotiating settlements?
Well, I think it's useful for members of Parliament to be aware of the recourse available to all Canadians, all about fairness. The Canada Revenue Agency has an independent ombudsman for service complaints who reports directly to the minister. If your constituents have service complaints, I encourage you to send them there. We have a dedicated complaint resolution program available to all members of Parliament to address constituent complaints. A taxpayer who's in financial hardship has the ability to be considered for financial relief, and we're quite happy, and those are available to all Canadians. A taxpayer who disagrees with an assessment has a right to an appeal. We have thousands of appeal cases. They have a right to be heard, and appeal can and will overturn an agency decision if it's in the interest of the taxpayer and in accordance with the law. And finally, on debt collection, as I saw in today's newspapers, we've been emphasizing that if a taxpayer has a debt beyond their means to pay, please come talk to us. We're happy to work out some resolution. These are available to all taxpayers. We encourage taxpayers all the time through our promotional things to take advantage of the benefits, the exemptions, the credits, the deductions that are available to Canadians. Mr. Gallivan on the...
Sorry, actually I have a question. How do we get in touch for taxpayers who can't afford to pay their debt? Who do we contact? Do they have to fax it in? Because that's the process that CRA has set up.
Gallivan?
Just quickly, taxpayers with the debt would have been assigned a collection officer, and they would have that direct phone number.
And we field about 23 million calls through our contact centres. I'm very proud of our employee service through the contact centres. This government has recently invested significantly, so we have been struggling with call volumes, and I'm very pleased this will give us the ability to be more responsive that way.
I sincerely hope that that does improve with this commitment of funding, because I have been told that once someone actually gets through to a live person, it's quite helpful. But the problem is they don't have the access to the live person. We don't have, the teams to contact. We don't have KPMG. The average person can't afford a $100,000 KPMG representative to negotiate settlements over months when their appeals actually take 9 to 12 months just to get a response. So my last question, because I know I'm running out of time, is that I'm just wondering if KPMG themselves have been issued any type of fines, penalties, fees for the Isle of Man.
I think Mr. Gallivan wanted to answer on the original point as well about getting to CRA, and Mr. Troish on your second question. Mr. Gallivan.
Thank you, Mr. Chair. Just briefly, at any given time like today, we have 230 high-end cases that are before the courts with large dollar values at stake. However, each year we give 400,000 Canadians taxpayer relief. We resolve over 90,000 tax appeals where a distinct part of the agency reviews for free the taxpayers' representations and makes adjustments where they see fit. So the numbers of ordinary Canadians being served by the agency greatly exceeds the quantum. In terms of access, one of the reasons I talked about executives needing to be accessible to not just KPMG and high-end accountants, but all taxpayers, in that same interview, I talked about how I personally, as a senior executive, reviewed all minister mail. If a taxpayer writes to the Minister of National Revenue or the Commissioner, somebody at my level actually approves the response, and we don't do so blindly. And so I think an important message is it's not just the large firms that have access to CRA executives, but it's the CFIB, it's boards of trade, it's accounting firms, it's bookkeeping firms, and through these other programs I mentioned, it's ordinary Canadians where the CRA reaches out to try to help them.
Thank you.
Thank you. I'll be very brief, Mr. Chair. Just for balance, I would draw your attention to the Volunteer Tax Preparers Program, where Canada Revenue Agency with a community group, some 16,000, help low-income Canadians, new immigrants, prepare their tax returns for free. Over 600,000 Canadians are supported by this volunteer programs. CRA employees volunteer of their time to support this program. And again, we're very pleased to see the government recent investment so we can further expand on the volunteer program.
Mr. Leipert, 5-minute round.
Thank you for being here, sir, and your team, and we'll see if we can get back to maybe the reason why you're here. I also want to make a couple of comments briefly at the outset that to support what my colleague said in his initial comments in response to what our chair opened the meeting with. Well, my particular constituency office will receive a fair number of calls from constituents who are dealing with issues on with the CRA. I must say that I don't think I can recall one particular concern by citizens on this particular issue. So, Mr. Chair, I can only attribute that to the fact that we have far fewer listeners and viewers of CBC in Alberta than they do in Prince Edward Island, Mr. Chair.
But I can tell you, I've got lots of calls on this issue.
I wanted to talk a little bit about some of the dollar numbers that have been thrown around, and I just kind of quickly walk through them. Correct me if I'm wrong, but I just want to confirm some of these numbers. It's my understanding that in 2015, the previous government committed approximately $15 million, and the return on that is somewhere in the range of $1.5 billion.
So I fully agree with the last part, that the return on actions from budget 2013 were 1.57. And in my remarks, that was actually 3 times larger than the estimate we had at the front. Where I may, I would love to say that that return on investment was on a $15 million investment, but that would not be, I think, an accurate portrayal. It's largely a result of the rebuilding of our approach to audit, and in particular, and under the leadership of people like Ted Gallivan, our new integrated risk assessment system to audits. This is where we've built a system within the agency that is used in our approach to large companies, those over $250 million in revenue. And we have it's based on a math algorithm with 200 variables. In other words, we have gotten better and better through business intelligence in where we focus our audit assets. And that came into effect right around the time. So that, along with the tools, produced the kind of revenue gain that you referred to, sir.
So one of our responsibilities is to ensure that the budgetary dollars that the government is putting forward are well used. And we've got just an incredible increase in the amount that's been provided to the CRA at a time when we're running a $30 billion deficit, I might add. At what point do you get to when the diminishing returns start to show? Because I heard you say that these additional dollars will allow you to do something like a 12-fold increase in examinations. But, I mean, it's one thing to examine something and spend a lot of time and money doing it. It's another thing to be examining something that's going to lead to these increased dollars. So I'd like you to comment a little bit on, and I'm sure you're not going to suggest that you don't want the money or you don't need the money, but is this an appropriate amount? Seems to us, to me personally, to be an awful lot of money.
It's an excellent question. $440 million in the recent budget invested in the agency to increase our ability to tackle tax evasion and tax avoidance. $440 million over 5 years. We are committed to returning to the government, to the Crown, $2.6 billion in revenue. That's the proposition. So, sir, your question is an excellent one about return on investment. Within the agency, this is a key factor as to where we mobilize our audit activity and resources. And we calculate that, and insofar as there is a diminishing rate of return, it's probably not an area for greater activity. Mr. Gallivan?
Just quickly, consistent with some of the feedback you may be receiving, these budgeted dollars are targeted in specific areas. There were dollars specifically for the promoters of tax schemes. There were dollars specifically to focus on people participating in aggressive tax planning. There were dollars to embed legal experts in our criminal investigations program. And so some of the money was to focus on those stubborn areas where the ROI might be lower, but the fairness of the regime is called into question if we don't police them appropriately.
How do you come up with the 2.6 billion? 2.8 billion, whatever.
We took our current yield and we cut it in half. In other words, we took our current average yield, and to be conservative in a mathematical sense, we cut it in half.
Ron, I know you'd like that conservative number. Mr. McKinnon.
Merci, Monsieur le Président. Merci tout le monde d'être là.
Thank you, Chair, and thank you to everyone for being here. My mother worked for the CRA all her life. It was her career. And for Revenue Canada, I'm sure she'd be very happy to hear the way the answers have been given by the witnesses today. My question is this. Ms. O'Connell reflects the perceptions of Canadians with respect to the ordinary taxpayers vis-a-vis the CRA. But I'm thinking in terms of a higher level. Canada, if I'm not mistaken, does not publish an overview of its tax record.
What you mean by tax record, or?
Tax gap. Oh, I'm sorry. I apologize. No, it doesn't today. But there was an announcement by the minister recently where there was a commitment made to begin a process to measure the tax gap in the future.
To moving down that road. What's important for me with the Canada Revenue Agency is that if we do this well. And I've certainly discussed with the IRS, I've discussed it with the United Kingdom, their approaches. There are areas that are relatively straightforward. There are areas which are very difficult, and I want us to go in. I want us to do this in a way that is open and transparent, but that educates Canadians so that these numbers have meaning to them.
Vous participez aux activités.
Participating in the activities of chartered accountants, and I'm sure it has been in the media, as you know. I would imagine when you have meetings like that, I'll give you an example. The other day, KPMG informed us that they do not, and I will read their quote to you, that they, if I translate it properly, that they do not deal in the construction of tax havens. In your meetings with these professional accountants, do you ever speak of issues like that?
And all of the employees of the Canada Revenue Agency, whether we're in a conference or whether we're in a meeting in a boardroom, in whatever setting, social or professional, we are bound by Section 241 and respecting that at all times. When I was appointed commissioner, my first briefing and the agency was on Section 241. When a minister is appointed, it is a minister's first briefing at the agency. So, of course, we discuss tax administration. We have messages to impart to tax preparers, and it's important for us to have that communication with them. They have issues to raise with us, but I don't deal, senior people don't deal with a taxpayer-specific information unless it's a representative of that taxpayer. Mr. Gallivan?
Peut-être juste vite fait, pour donner un exemple des sujets que nous abordons.
Just to give you an example of the subjects that we might deal with, we had receivable accounts recently. There, in an instance where they were playing with their accounts payable, we detected the behavior of this entity, and then we were able to deal with it. We got them to stop that type of behavior because otherwise you will go before the courts. We give a message that is intended to influence the behavior of the accountants.
Change de sujet parce qu'on a très peu.
I'm just going to change subjects. Ms. Brooks, how was she chosen?
A number of names were developed within the agency of people who had considerable expertise in tax law, people of good reputation, and then those that were available in the timelines that we had. Ms. Brooks was either at the top of the list or there. She was contacted. She was available.
Donc, vous comprendrez que...
So you'll understand that there is a certain transparency in the choice of the person who reviews our behavior is very important. And I think that is something that should be said out loud. I'm going back to the 2013 report. Are you... of the AG, where he made 2014, spring 2014, when he made 2 recommendations. Can you give me an update on the progress that you have made in terms of the commitments you made under the 2014 AG report? They have been updated. The one that deals with specific risk, you can see the results. We calibrate it. And I would say that the management of risk is working very well indeed.
Thank you very much for being here today. And I'm sorry that I may be repetitive because I wasn't here at the beginning, but I was responding to the minister's introduction of the Budget Implementation Act. So I hope I didn't go off topic there on you. No. Okay. I'd like to understand a little bit more of your internal process. I asked the witness from KPMG the other day how many actual prosecutions are ongoing or do happen in a year with respect to tax cases. And I'm wondering if you can give me an idea, because what I'm looking at is specifically what our preponderance is to proceed to prosecution as opposed to settlements.
Yeah, welcome. Earlier on, I spoke about the broad numbers. I spoke of 5,000 cases in litigation. I spoke about the cases which go to court, about 2,200, and those where a settlement is reached, which is about 3,000. Prosecution, we haven't touched upon what's an important distinction between instances of tax avoidance, aggressive tax planning, versus tax evasion.
Right.
Tax evasion being a criminal matter.
Yeah.
These two are often blurred in public commentary and discourse, but for the Revenue Administration, it's a very, very material distinction. For a criminal offense, tax evasion, there's a very high burden on the Crown, an evidentiary burden. To successfully prosecute, we have to prove beyond a reasonable doubt that the taxpayer made false or deceptive statements. We will have to take that case to the public prosecutor, who will ultimately decide whether to prosecute. Tax avoidance, aggressive tax planning, the burden on the agency or on the Crown is lower. It's where we're looking for a taxpayer that's received a benefit that is contrary to the objective or the spirit of the Income Tax Act. We can then reassess them on that basis. And then a tax court ultimately could be called upon to review the validity, and that's based on a civil standard of proof, balance of probabilities.
How many cases do you end up sending off to public prosecution service?
I would say 200 a year are referred.
And they're mainly for tax evasion? Or solely for tax evasion, rather?
They would be 100% for tax evasion. In 2013, we made a strategic shift to focus more on offshore and promoters.
Yeah.
And so as a result, kind of pre that shift, we had, in the 2 years before, 26 convictions. Since then, 2012 to 2015, we've had 30 convictions. But what's important is the jail terms. The jail terms are up 95%.
Okay.
And so we kind of made a strategic choice internally to focus more so on offshore and promoters, and that's what we're doing.
Okay, thank you. What's the timeline usually? Having some experience in having files of being with the Public Prosecution Service, what's your timeline from the time you deliver the brief to when they make a decision? Or do you have to have certain deadlines you have to hit yourself? Limitation periods.
Yeah. I think it's more interactive than that, and that's why the recent budget gave us money to embed legal counsel with our investigation teams, because I think we don't want to waste a lot of hours on a file just to find out kind of we don't have what we need. Yeah. But you're correct, prosecutions often 3, 4, 5 years from the date we make the referral to our investigation function until we're before a judge.
Yeah, that's what I thought. Quick question on post-employment duties. KPMG testified as well the other day that they too take very seriously the fact that an oath is taken by your folks, and my point is that well, I'll tell you what they said, and they said that they make sure that these folks self-identify and self-acknowledge whether or not they're abiding by the oath that actually follows them into employment with an outside force, meaning that it's not a cooling off period. Like once you take that oath, you have to promise never to use information that is not publicly available, which I think is a difficult test on a day-to-day basis, trying to figure out what's there or not. KPMG takes the view it's the individual's responsibility. Does CRA do anything in terms of monitoring post-employment practices? And I would tell you the reason why I'm concerned about it is this. It's one thing to act as if you are an employee of a competitor or another company going to a different firm, as opposed to an oath you take to the Canadian public as a public servant to not do anything to harm the trust that's imposed upon you in the public service. So with that, I'm wondering if whether or not CRA has anything that they do to monitor and or track what happens to your folks who leave after a wonderful career in the public service.
Excellent question. Thank you. I'll ask Deanne, but I want to put some numbers here in context. I think it's important for the public record. There was a media report focusing on former CRA employees who went to work for the Big Four firms, correct? In that report, 21 former CRA employees were identified by name. The media report shows that the reporter went back to people who departed in 2001. So we're talking over a 15-year period, in which was the basis for this story. So I would indicate, while we take very seriously our obligations to have rigorous post-employment policies, I don't know that any post-employment regime would follow employees 15 years after their departure. And a court, I would assert, referring to a Supreme Court of 2009, would find that an unreasonable, unjustifiable infringement on the right of a livelihood of a tax professional or a chartered accountant if they were asked to forego their livelihood for up to 15 years. Right. Of those 25, remember we're an agency of over 40,000 people. Yeah. So over that period of time, 25,000 people left the agency. The vast majority left to retire. So we're talking about less than 0.1%. And I would say, by point of comparison, we have more former employees who are proudly serving in Haiti and third world developing countries under the World Bank and the IMF than they are going for these firms. Yeah. They're in hardship places. I have more employees now who are supporting the voluntary program helping low-income people. I have Suzanne Lachance in Winnipeg, who was given the Governor General's Caring Award for her 25 years service under that program. Those aren't news, are they?
No.
Diane, a quick point before Mr. Trosh takes all your time.
So our post-employment policy makes it very clear to our current employee that they have to respect the oath. Now, when they leave the agency, we have a letter of post-employment that they must sign, and they agree that we are going to share the letter which provides the restriction of those employees to their new employer. So we have two avenues. Okay. One is to really ensuring that the new employer is aware of the restriction so that they can monitor, but also when we are made aware that they are in breach of that permanent restriction, we can file legal proceeding.
Oh, great.
Yes.
Okay, thank you. That's very helpful. I appreciate that. And I hope you don't think that my question was in any means trying to, I was just trying to clear the facts up for you guys, that's all.
No, and I apologize if my response seemed that way. I'm
That's okay.
Very pleased to see the interest of the committee in issues of tax administration, and in particular in what is a genuine issue of great concern, international tax evasion avoidance. But I am extremely proud of the employees of the Canada Revenue Agency, including everyone here, who are hardworking and dedicated official, and the occasional commentary from some sources that seem to defame or call into question their professionalism and their integrity, but it's in no way related to your questions, which are entirely appropriate.
We have to stop there, Lisa.
When did you turn in? When did Wayne Easter turn into Ron Leifert? It's confusing.
Thank you, Commissioner, and thank you to your staff, your colleagues for coming today. I think the heart of the issue is why constituents in my riding are particularly upset is about fairness and the perception that all Canadians are paying their fair share. And there's also the second element, which in my humble opinion is a perception that the CRA treats everybody equally, that it's not just the people that can afford to hire KPMG for $100,000, and the perception that they're getting a better deal than the truck driver, the taxi driver that's being audited for their receipts and their gas receipts and stuff like that, and they're having to spend so much time, and not just the money and the effort, but their time, and people are very concerned when the CRA picks up the phone and starts reviewing their file. And so I think that's where the heart of the issue is. And an internal audit for the CRA in October 2010 said that the agency had concerns that they didn't have the resources to deal with complex cases, specifically international tax evasion, because of a lack of resources. And it was the previous government that cut heavily into the CRA. So my question, and please be very brief because I have a lot of questions, had the previous government's cuts had an impact on the CRA being able to fulfill its mandate specifically on international tax evasion?
On the first question, and I'll try to be very brief, we have increasingly taken a very different approach to small and medium-sized enterprises than to large international global enterprises. Increasingly with small, you are seeing far fewer deployment of audits, and you've seen that we've introduced the liaison officer initiative. Rather than come and approach a small business person with an audit, we're moving our resources to come to small business with a helping hand to say, how can I help you? You're a plumber, you're an electrician. It's probably good that we sit down with you and help you so that you can avoid some of the mistakes that you're making. Where we are redeploying our resources to international and large business. So I've served two governments. I serve both governments loyally. We work with the resources that governments give to us. Obviously, we have come through a period of considerable fiscal restraint, but during that period, we redeployed as best we could all of the resources to be more stronger and more effective. You're in a 5-year period there. And we have been given some tools. The new budget gives us an enormous reinvestment that will be a return for the Crown and will, I think, move us forward in addressing the concern that I know Canadians have, as will international efforts.
Thank you. The CRA determination of whether tax avoidance has occurred is made on a balance of probabilities. So tax avoidance, balance of probabilities, which is a lesser threshold than beyond a reasonable doubt. Now, in your opinion, did the taxpayers that participated in the Isle of Man tax scheme participate in tax avoidance on a balance of probabilities?
Mr. Gallivan.
Again, taxpayer confidentiality prevents me from responding specifically.
But it's not specifically. It's if you hypothetically, if you participated in a tax scheme like that on a balance of probabilities, did you participate in tax avoidance? And it's a simple yes or no question.
Well, to me, it's not as simple because first I have to state on the advice of Department of Justice that I can't comment on specific taxpayer situations. What I will say is the CRA examines every case based on its facts. I think I can allow that in this case, even though there was the Isle of Man has been applied, there could be variations. There could be variations in the approach by the taxpayer, and those facts may vary. Finally, our work on this matter is far from done. There are files active before the court in respect to tax assessments that we've levied. There's action in front of the courts with respect to obtaining additional names. Our minister announced April 11th that we're pursuing all Canadians who have interaction with the Isle of Man to risk assess those transactions. So our work is far from done.
Thank you. Lastly, I think we can all agree on the committee that the balance between a regulator and those who they regulate is pretty sensitive. Now, I'm going to refer to your Code of Integrity and Professional Conduct and quote directly from the duty of loyalty portion. And it says, I quote, employment in the public service requires the acceptance of certain constraints, which should be considered in our day-to-day activities and our off-duty conduct. And now I will refer to the CBC's report on April 17, 2016, where 20 CRA officials from the Compliance Division were not only invited, but required to attend an after-hours reception. Now, I was a lawyer in my previous life, and you have to attend professional settings. I understand that people at the CRA are CPAs, but the conflict of interest comes from this, in this specific case. CRA officials from the Compliance Division, individuals from KPMG, and individuals from the CPA. And the CPA hosted the event. Now, generally, that wouldn't be an issue, but the CPA applied for intervener status on the issue between the CRA and KPMG. So now that puts the CRA in a direct conflict of attending a CPA and a KPMG event. And in that story by CBC...
Mr. Graywell, would you wrap it up? You're well over.
Do you not think or agree that it was a conflict of interest for the CRA to attend when CPA applied for intervener status and KPMG officials were there?
Well, in broad strokes, CRA could never leave the Connaught building if we were concerned that we were going to come into interaction with the taxpayer or taxpayer's representative with which we had issues. Given that there are 100,000 appeals in a year, 5,000 litigation cases, all of these are potential there. I don't believe it's our conduct, it's not our attendance. Section 241 continues to apply in all of these instances.
And I say it from my perspective.
Oh, I've got to wrap you up. You're already hitting 7 minutes, my friend.
Thank you.
Mr. Dussault.
Thank you, Mr. Chair. Just to come back quickly on the letter that was on the CBC website. Madam Anderson, can you confirm that the signature that we see on the letter is your signature? That if I ask you to sign on a piece of paper, would that be your signature?
It appears to be my signature, but I can't confirm that it's an actual document that I signed because I don't know the source of the document.
Okay, so knowing that, I would ask Mr. Trish, if you can come back, I would like to ask if you can come back to the committee just to confirm that that letter was sent. I understand the legal implication of providing us the letter itself, but can you come back to the committee to confirm that this letter was sent? It's an actual letter, if it were sent or not?
I think this question has been asked and answered by me and by legal counsel that we're unable by Section 241 of the Income Tax Act to enter into that kind of discussion.
I don't want you to provide the letter itself, just to provide us if you did send that letter or not.
I sent no letter.
And why?
Pardon?
Why? We just, as parliamentarian, we want to know if you did send that letter. It will help us in our work.
Perhaps you mean as a representative of the Canada Revenue Agency rather than myself. But I'll ask Ms. Lovett again to talk about the legal restrictions that binds all revenue agency employees.
So I spoke earlier about Section 241 of the Income Tax Act. Without referring to any specifics of what may have happened or not in the KPMG litigation, I can say that anything that would have been sent in that context would also be subject to settlement privilege. And so I believe that your question is an effort to determine whether or not this specific letter was sent in that specific case, and Ms. Henderson isn't in a position to answer that question.
Thank you. Now, turning on something else, je ferai une analogie avec.
I'm going to draw an analogy with the situation we have before us and a theft at a bank where there's a robbery. Masked men go into the bank, rob the bank. The bank is surrounded by police officers, and when the masked robbers leave the bank, the police say to them, "Give me the money." There might be some penalties, and then they let them go. You will never be prosecuted. We can't identify you because you have masks on. Give us back the money. Thank you very much, and goodbye. Is this an analogy that I can draw with the KPMG case, where it's clear in the document that was posted at the federal court?
Mr. Russell Lyon, auditor of Victoria, British Columbia, he swear in an affidavit filed to the court. As a result of the compliance audit of the taxpayers, the CRA position is that the taxpayers, through the offshore company structure set up for them, did not cede control and influence over the assets they caused to be transferred to the offshore company. And he says, the CRA's position is that the investment
Mr. Dussault, I'm going to have to get you to wind it up. You're well over time.
So just to finish, he said the assets is taxable in Canada and the taxpayer's end, and that they are required to file Form T1135. So why, if you know that it's illegal, why would you offer an amnesty?
To take up your analogy, again, I can't confirm that that document represents an actual offer, and I can't disclose any specific taxpayer information. But in cases like this, the analogy I would use is more before the courts, and an accused who's willing to plead guilty but wants to have a conversation about the sentence. From the perspective of the agency, there's always a legal risk around our position. We've taken the position that the specific Isle of Man structure is not compliant. Only the courts can give us a final determination, and that hasn't happened yet. We sought information from KPMG because we wanted to hold those participants to account, and we're in court trying to get those names. We have no guarantee that we'll be successful. And so in a situation like that, if there was a theoretical opportunity to get value for the Canadian taxpayer, the agency might do so.
Thank you, Mr. Chair. Just want to put a motion on notice.
Okay.
The motion, so it's just a notice, so I would like to discuss it later. It's related to what we are discussing right now. That the committee compel the Canada Revenue Agency to provide all written correspondence, including, but not limited to, letters and emails between the Canada Revenue Agency and the KPMG SRL accounting firm, issued between January 1st, 1999 and May 5th, 2016, regarding the Isle of Man tax plan and any matters related to that plan, and that the documents be provided to the committee no later than Wednesday, May 18th, 2016. So it's just a notice. I would like to discuss it later at committee business.
Okay, notice is given. Mr. Sabera.
Thank you, Mr. Chair, and thank you to the witnesses this morning, I guess this afternoon as well. Since I'm batting cleanup, if I can use an analogy, I'll just ask a couple of questions. I think a lot of stuff's been asked. There is mention that a tax gap study is currently underway. Any idea of when that will be available or completed?
The minister announced the government's approach to tax gap. She announced it April 11th. It will be a series of things as opposed to one big bang. What she committed us first was to a conceptual paper on the definition of tax cap, on approaches to measurement, onto the methodological issues and the approach that the agency would be taking. She also committed to a specific tax cap, and I think we were fairly clear that it would be the GST, HST domain would be the first thing, and that was committed for before the summer, as I recall.
Okay, thank you. Second question is, we've heard a lot of noise, or say the complexity of our tax system in Canada and the amount of what it costs both businesses and individuals. I think the number that was thrown out was something like $25 billion for compliance, and from everything from someone like myself preparing my taxes at home to a large multinational corporation. I think it would behoove us to possibly take a look at cleaning up our tax system. On that tangent, how confident, and I'm really curious about this answer, on the transfer of pricing issue with respect to businesses and multinationals, because transfer pricing is an issue where the line between tax avoidance and the other side, it can be easily blurred from my accounting background. So how confident is the agency on the transfer pricing file?
These are excellent questions. First, on complexity, any commissioner of a revenue agency would prefer to have a tax system which was simple, that would be clear and would reduce compliance efforts. All Canadians would welcome that. I feel a little torn, to be honest. I think that is a good outcome for individual taxpayers, and in particular for small and medium-sized business, particularly micro enterprises, where I feel there's ground for improvement. Where I feel ambivalent is large global enterprises with very complex structures and financial things. And you refer to transfer pricing. These are not simple, and I think it would be naive to think that they ever could be simple. Transfer pricing, if you could elaborate, Mr. Gilliman.
Just quickly, the OECD has released a BEPS action plan, including 15 items. 9 through 11 relate exactly to transfer pricing. Those new global standards very much represent the Canadian model. And so it makes us feel that both in the past we were on good footing, going forward even more so. Secondly, as the Commissioner alluded to, the 1,200 economic entities with more than $250 million in gross revenue are under real-time risk assessment. And every year we do a deep dive, and 100% of those that we consider to be high risk are audited. That's why last fiscal year we had an $11.3 billion fiscal impact, up from $8.7 billion in 2011-2012. So the multinationals and transfer pricing are a strong focus of the agency.
Okay, and I have like a minute or two. One of the things I'm glad to see that I think 6,400 auditors will be hired, or in addition to, so you'll have more resources, and I think that's wonderful. I also take a step back and say I hope some of those auditors don't show up at the doors of some of those individuals working very hard and may have made a simple mistake in my riding. They'll feel the wrath of the MP who represents those residents. I've had to deal with a couple tax issues where liens were put on people's homes for insignificant amounts, or what at least I consider insignificant amounts, where CPP and old age security were garnished. I think that's a proper term. Where we've had to help the individuals out, and we've taken steps with them, and obviously guide them to go to an accountant ultimately. So I do hope that the auditors that come on board understand that not only are we dealing with businesses and stuff, we are dealing with individuals' lives and livelihoods. We are dealing with sometimes people that generate a lot of economic wealth for our country and for our constituencies, and that we're there to work together, not to go against them.
Thank you for the question. On the first part, the reference to 6,000 plus auditors, that is the number of auditors we have today.
Okay.
That's over the period of fiscal restraint, and the indication I had that we were still able to grow our auditor complement by 20%. Going forward, following budget 2016 and the $440 million investment, we will be again very active in the field, which is why the question about post-employment is a really important one. we're going to have to be hiring for attrition in the budget thousands of new employees, so we need to get the balance right. The second part of the question was about debt collection. There is a video that we've put up and a lot of promotion. The revenue agency has to uphold the law to collect debts owing to the Crown. We're really encouraging people to come forward to talk to us. You'll see an article in this morning's Globe and Mail with the same message there. Talk to us. Where things get difficult is where a taxpayer avoids the revenue agency, doesn't respond, and then over a period of time, we are required by law to take some of the actions that you're referring to.
10 seconds or 20 seconds. And I'm just reading some of the information on the voluntary disclosure program. It seems that the program is working well, if I can say that. I'm always curious about the difference between the voluntary disclosures program versus the negotiated settlement agreements. When CRA comes to a business or an individual, and I don't want to say offers that choice. It may not. I may be choosing my words incorrectly, but you have voluntary disclosures. You have negotiated settlement agreements. When an individual moves from one bucket and then goes to the other bucket, in terms of CRA's view, where a person may have been able to come forward, did not, and then gets put into this second bucket where there's a settlement agreement that may be negotiated.
I'll answer part. Ted Gallivan can complement Lee. One measure, I'm asserting that we've been more and more successful in tightening the noose around offshore tax avoidance and tax evasion. What's a way of measuring that? Well, when people come forward under the voluntary disclosure program, it shows that they're becoming increasingly worried that they can't hide from us. And our voluntary disclosures have been up 400% in the last 6 years. And so that's $1 billion in tax that we wouldn't otherwise have found. So I think that's accumulation of all of the things that I spoke about in my opening statement. Mr. Gallivan?
Just quickly, the voluntary disclosure program is primarily targeted to Canadians who want to come forward. Often it happens within a state, and so one generation of a family passes away, the next generation has this wealth they weren't expecting, but they find out that it wasn't tax compliant and they want to move forward in compliance with the law. That's who that's for. In terms of legal settlements, usually the CRA is already on the case, either with a specific taxpayer or through an unnamed persons requirement. That's a very different setting. And through those legal agreements, we'll seek to assess the facts and reach an agreement where it makes sense for the taxpayer. And in some cases, we won't because the offer isn't there. And in other cases, the principle or the precedent is so important, the agency won't come to an agreement.
Thank you. We are out of time. I just got one quick question. Is there an accounting company is coming up with a, say, a tax reduction scheme? Is there a process where they can get an advance ruling from CRA? Does that happen? What is that process?
Yes, sir. We do provide rulings, and it's a significant part of the responsibility of the revenue agency, where we're asked to provide a ruling, and it's an important part of our responsibilities.
Okay, with that, I would thank you, Mr. Troche, and all the other witnesses from CRA with you. Thank you very much for coming here this morning.
Thank you, Chair.
We will suspend for a couple of minutes and then come back. Convene, and as indicated at the last meeting, we were dealing with the motion from Mr. Dussault. Do you want to reread that motion, Mr. Dussault, and we'll go from there? If you have it.
La motion.
I can.
Point of order, Mr. Chair. Who is the NDP member on this committee?
Who swore in? Mr. Caron. Sorry, Mr. Caron is officially the member, so Mr. Caron will have to read it.
Est-ce que vous pourriez répéter la requête? Quelle motion vous voulez que je lise?
Which motion would you like me to read? Can you repeat, sir?
Mr. Dussault, at the last meeting, that the committee compel KPMG to provide documents. That one.
Merci. Alors, la motion qu'on avait...
Thank you. That we undertook to discuss is the following, that the committee compel KPMG to provide documents indicating the names of clients with the exception of
documents indicating the names of clients who used the Isle of Man tax sheltering scheme and the names of KPMG employees responsible for the development and marketing of the tax scheme.
It's on the floor. Okay. Do you want to? We were in discussion on it previously. Is there any further discussion, or are we going to the question?
I'd like to propose an amendment.
Mr. Sabero first.
I'd like to propose an amendment to the motion.
Could you read it and then we'll distribute it? Absolutely. We got it. Do we have a? Okay.
That the committee requests that KPMG provide detailed information, including where legally allowable, documentation concerning the Isle of Man and other offshore tax shelter schemes, as well as the names of the KPMG employees responsible for the development and marketing of those tax scheme.
I'm just trying to figure whether this amendment's in order or not. Mr. Caron, what's your point?
I'll submit that this is not in order. This is not an amendment. This is a new motion that would be replacing the intent of our motion.
I believe you are right, so I will rule the amendment out of order, and we're on the original motion. Mr. Caron.
We did start the argument at the last meeting regarding the importance of this motion. La motion que nous présentons est importante parce que présentement,
it's important because presently we have 3 meetings dealing with this, 2 of which have been dealing with KPMG. Today we have heard the representatives of the CRA and the Department of Justice. And then on the 19th we will hear the minister. However, and in light of the 2 meetings that we have had so far, it's very difficult to ascertain everything that has happened so far, particularly with respect to the way the mechanism operated. It's important for us to be able to represent taxpayers in terms of the tax system. We want to be able to pursue this matter to the end of the inquiry. And therefore, from our perspective, we think that the names of the people who participated in the creation of this mechanism, of this scheme, the names of those who benefited from it, and those who interpreted the legislation in this way should be given. The representatives of KPMG as well in this specific case should be known. We would like to have the possibility of amending the word compelled by request. It is very important to use the power of committee to obtain this information and documents, because they may well just refuse without any type of obligation on their part. Here I'm referring to KPMG, and therefore we will be no further ahead. If KPMG refuses to supply the documentation, we will find ourselves in a very difficult situation. We won't be able to pursue this matter to the very end.
Aims at ensuring that this issue will not slide will not go down to oblivion, but that will continue to actually do what we have to do as a committee, which is to actually ensure that this is well understood, this will not be repeated, and that that we will hold the people who are responsible, if that is the case, to account.
Okay, Mr. Graywell.
Just a question to the clerk, or to be honest, any committee member for some of the new members on the committee. Does the committee have the legal authority to compel KPMG to release names? I mean, if something like this is in front of the court, and the government of Canada has already made this request, I mean, where does the committee roll? Like, is this just a motion for the sake of, you know, the motion, or is there a legal method to actually compel KPMG to release names?
At the last meeting, Mr. Graywell, we initially thought that this would be a out of order as a result of subjudiciary. People within the clerk's office felt that was going too far, and that it should be debated. So that's why it is on the floor. So it'll have to be debated in a decision made by committee. Your point, it's close to the line. There's no question about that. Mr. Caron, Mr. McKinnon first, and then Mr. Caron.
Listen, I would be opposed to the motion that has been moved by my honourable colleague, and I would support the motion that has been moved by my colleague, Mr. Sorbera, if it meets the opinion of the court. There is a case before the courts at the present time that has been funded and by the taxpayers of Canada and Her Majesty the Queen, precisely to have access to the information that Mr. Caron is seeking from us. I know that if his motion is in order, his motion would constitute another court challenge, which would lead to thousands or even hundreds of thousands of dollars in legal costs for the taxpayers of Canada. I think we would prefer then to let the case before the courts come to its conclusion. And indeed, if Mr. Sorbera's motion is passed, well, we would ultimately have the information that we could add to the testimony that we have heard. We've heard 3.5 hours of testimony here in the committee, allowing us to pursue the matter to its end. But we get to the same place in that way without uselessly provoking any further costs before the courts, which may well duplicate, overlap what is presently before the courts. I oppose, therefore, the motion.
And I just want to clarify one point, because some people have questioned why was it the motion ruled out of order. The original motion states names of clients, and the proposed amendment states the names of KPMG employees. So it is substantially different in that regard. Mr. Caron and then Mr. Ouellette, and if we could go to the question.
Merci, Monsieur le Président.
Thank you very much, Chair. In fact, I would say that the major problem with the way that the Liberal side is operating right now is the following. The case before the courts is not really before the courts. It's an application by the minister. and yet we are formulating something similar here in committee. The minister is asking for the names of those persons responsible, the names of those persons who benefited from the scheme, and we can't do the same thing. We're talking about the 6 individuals who are before the courts at the present time. They can be set aside from this motion. As far as the rest are concerned, they have benefited from the amnesty and therefore have been removed from culpability. There should be no problem for us to ask those persons responsible for the carrying out of the mechanism to have their names published, and to ask what is going to happen also if nothing is done. The Government of Canada may well be prosecuted in its own right. Do we want really in committee to do things? Do we want to defend the system? Do we want to preserve the taxpayers' money? Do we want Canadian taxpayers to have confidence in the system, or do we simply want to dilute a motion so that ultimately KPMG has absolutely no obligations at all, is not bound at all because this is too risky a procedure to follow? We are asking KPMG to provide that information, those documents. If it refuses to do so, they will have to defend their decision before the court of public opinion. And the choice of the government, therefore, or members of the government, is very clear. Do you want to dilute, water down the motion? Do you want to let it just slip away so eventually people forget about it? Or do you want to use the committee's power and ultimately the powers of the House to for public ends to ensure that taxpayers and citizens are well represented and well defended? That's the government's choice.
I would submit that there is no question being called in this committee. So if somebody else wants to speak, they're welcome to do so. If nobody, then we can move to the question.
I don't see anybody speaking.
That's fine. Mr. Ouellet was on the list.
Okay, Mr. Ouellet.
I guess we want to go to question pretty quick. You know, one of my issues is, you know, the names of the clients, and I think, you know, has to be a certain level of fairness and privacy for individuals, you know, when they're dealing with the Canadian Revenue Agency. And I'm, you know, in the political environment here, I'm not always certain that that's perhaps the most appropriate means to be dealing with something, especially concerning people who, you know, we don't know their situation in their lives. And so I'm a little concerned about that because I'm very concerned about the idea surrounding privacy. But on the other hand, you know, when we first started this idea of going and looking into KPMG and the Panama Papers, and this was in the media, the idea, I believe, the original intent was that we would, you know, discuss with the officials, and then we would see where that would lead us over time. And so I'm very supportive of the idea of getting more names to have greater discussion and trying to understand about, you know, how these tax havens work, you know, the Canada's implication in the international community. But, you know, I think this is really what we should be trying to get to, is trying to get more people here so we can truly understand it, get them on the record, and really trying to gain a greater understanding of that. Now, I'm not sure what everyone else thinks, but I would actually like to propose, you know, not a substantive amendment, but a slight change. Because I don't think my change will be major in any way. But the idea in this one is to remove, for instance, the word compel and just have request. That does not preclude in the future that we cannot, if KPMG refuses to provide that information, coming back and trying to deal with this again, and also just removing the names of clients. So essentially, the original motion that the committee compel KPMG to provide documents indicating the names of clients who use the Isle of Man tax sheltering scheme and the names of the KPMG employees responsible for the development and marketing of the tax scheme, and replace it with that the committee not compel but request KPMG to provide documents on the Isle of Man tax sheltering scheme and the names of the KPMG employees responsible for the development and marketing of the tax scheme. And I don't believe this is a substantive change to this motion. I believe it's still in the spirit of what you're trying to get at, and it wouldn't preclude later on coming back if KPMG refuses to provide more documentation to this committee so that we can continue to do our work and really get to the bottom of what's going on. And I applaud, Mr. Dussault and Mr. Caron for, bringing this to the forefront.
So, you're moving an amendment that would read, we're all clear on this, that the committee request KPMG to provide documents on the Isle of Man tax sheltering scheme and the names of KPMG employees responsible for the development and marketing of the tax scheme. That's the amendment?
Yes.
All right, the amendment is on the floor. I can't see there's a problem with it. The amendment's on the floor. Go ahead, Mr. Caron.
Juste rapidement, merci.
Quickly, thank you, Mr. Ouellette, for having moved that, but really the question is so important. And the meaning of compel is one that we would like to see passed. We may well just have from KPMG as a single name. With respect to the names of the clients, we would be inclined to agree to that, to set that aside. But given that amnesty that was discussed, I think that the committee should understand the way in which the mechanism is working. We should know who the persons were. In that somebody should come here to appear before the committee to explain how the system worked.
Thank you for the time, Mr. Chair. I am in support of the amendments because I too share the concern over the names of clients. I think that there's almost a assumption of guilt here of individuals who may be proven not guilty if this was a legal case in front of a court, which it appears that it may be, and that if we compel names of individuals and wrongly suggest in the court of public opinion, as Mr. Caron has said, I think it's totally out of line to do that to any individual and their privacy rights. So I agree to remove the names of the individuals, and I support changing it to request, although it's not a big issue for me one way or the other. It's more the protection of the individuals who may be involved here and may be proven that they did nothing wrong at the end of the day, and yet we put them out there. And frankly, I'll say this too, that as we politicize this issue in the House of Commons, as was done yesterday during question period, it begins to imply or perhaps even accuse people of guilt where there may be no guilt. And that happened yesterday in the House of Commons, and I was not pleased about that.
Okay, do we have any more discussion, or can I go to the question on the amendment? All those in favor of the amendment? Opposed? Amendment's carried. So the motion as amended, any discussion? All those, Mr. Caron.
La manière que c'est abordé.
The way in which it was dealt, I don't know if the government members will accept it, but it seems to me there's a major problem with the motion. There's no date in it. There is no date by which we ask that the documents be submitted to us by a KPMG. So, could we include one?
But it was compelled. It was very different.
Okay, yes.
So I will actually propose an amendment to say that we want these documents by Wednesday, May 18th, 2016, of course.
Is there general agreement on that? Agreed? Logical. That we request the documents by May 18th? Okay. then that's assumed to be in the motion. There's general agreement on the motion as amended a couple of times. All those in favor? Opposed? Carried. I know we've got a number of other issues, and we only got about 2 minutes. And one of them relates to our work next week in order to get a start on the budget bill. Can we deal with the motion to deal with the subject matter of the bill on Monday? Mr. Caron. I'm just asking for if there's agreement or not.
Une question à la greffière, cependant. Est-ce que...
A question to the clerk. The motion, was there a 48-hour notice given for the motion? Is
so we can discuss any motion that's related to the business of the committee. No. At a committee meeting, there has to be 48 hours, but not for committee business. Committee business is wide open. Any business that you want to deal with that relate to the committee. Let me put it this way so that we at least, could we have agreement to go this far, because I know we're going to have too long a discussion to go to the subject matter of the bill. Is there any way we could get agreement at Tuesday's meeting, regular slot, and go from there, to have finance officials on the subject matter of the bill? Could we go that far and agree on that so that we've got at least a start on the subject matter of the budget bill? Is there agreement?
Oui.
Yeah, Mr. Caron.
Je m'opposerai pas à ce qu'on le fasse.
I wouldn't oppose our doing it on Tuesday, but I would like to register my disappointment to see that the government is proceeding in this way. We've just started the second reading debate today. I sincerely believe that I hope this will not be the beginning of a new trend on the part of the government to have us deal with it here before there has been any significant debate in the House at second reading for the purposes of this committee. So I again say that I am very uncomfortable to see the government proceed in this way. I don't see any type of hurry. And if the government members could indicate how long the study would last, how many meetings we would have to have, will we need more witnesses, and so on.
And this is one of the difficulties without having a parliamentary secretary in the committee. Could I ask that maybe I'll talk to the parliamentary secretary and we'll see what they feel the time frame will be, Mr. Caron, and we at least start with a regular meeting on Tuesday with officials of the department on the subject matter of the bill. That may even be helpful for us in the debate in the House of Commons, and then we'll plan our schedule from there. So we really only at the moment have the 2 meetings planned for next week. One would be Tuesday on the subject matter of the bill, and we have the Minister of National Revenue on... Oh, that's the following week, is it? Okay, we'll have to deal with it at Tuesday's meeting, where we go from there on Thursday or those days thereafter. Last point, Mr. McCone.
As I look at the committee calendar, we've got all the month of June available to us. So I don't know what I guess I asked the question, why the hurry up when we've got all this time that we can do this in regular committee meetings?
You made your point. So on Tuesday, we will hear from officials on the subject matter of the bill, and we'll plan our agenda from there accordingly. Meeting adjourned.